Hi, everybody. This is David O'Day with O'Day Schneider PLLC, and today I'd like to talk to you about unlawful command influence. Unlawful command influence is known as the mortal enemy of military justice. Under Article 37 of the Uniform Code of Military Justice, no person subject to the UCMJ may attempt to coerce, influence, or otherwise interfere with the independent judgment of a court martial. This prohibition extends to convening authorities, commanders, senior enlisted leaders, and anyone acting within the mantle of command or authority. Unlawful command influence, or UCI, is not limited to actual interference. Even if the appearance of influence can undermine public confidence in the fairness of the military justice system, that can be UCI. A court martial must be free not only from improper command pressure, but also from the perception that such pressure exists. There's two types of UCI. The first is accusatory UCI, which occurs before trial. This form involves the preferral, forwarding, or referral of charges. An example could include a commander being pressured to refer charges that they might not otherwise refer, or being discouraged from dismissing charges because of outside influence or perceived policy expectations. Any action that suggests command policy dictates whether a service member is prosecuted risks accusatory unlawful command influence. The second is adjudicative UCI, which happens during or after the trial. This can include attempts to influence the court member's deliberation, stacking the panel to reach a particular outcome, discouraging or intimidating witnesses from testifying, or making public statements that imply an expected result of trial. Even subtle actions, such as senior leaders criticizing past sentences or announcing a quote, zero tolerance approach to certain offenses, can create unlawful influence if they are reasonably seen as pressuring the court. Now, once UCI is raised at trial, the burden shifting framework applies. The defense only needs to present some evidence of unlawful command influence. This can be a relatively low threshold. And once the issue is raised, the burden shifts to the government. And the government must prove beyond a reasonable doubt that either no unlawful command influence occurred, or that any influence will not affect the proceedings, or that that taint has been cured. The military judge's benchbook provides clear guidance on how judges address UCI. Judges will make records of the allegation, conduct an inquiry, and if necessary, take remedial actions. Remedies could include questioning witnesses and members to ensure impartiality, giving what we'd call curative instructions, excusing members who have been influenced, or even in the most serious cases, dismissing charges. These steps are taken to preserve both the fairness of the trial and the public perception that the court martial process is independent and just. UCI can come in many forms. It could include a commander directing or implying how court members should vote, punishing panel members for prior verdicts, issuing public statements that predetermine outcomes, discouraging defense witnesses from testifying. Even when no actual prejudice is shown, the appearance of command pressure can require judicial intervention to maintain confidence in the system. The takeaway is clear. Unlawful command influence undermines the legitimacy of the military justice system. Commanders and leaders must avoid any conduct that could appear coercive, and defense counsel obviously need to raise these concerns promptly. At the end of the day, UCI is at the heart of the things that could damage the military justice system. As always, no video is legal advice, and should you have a real legal issue, you should talk to an attorney who specializes in military justice matters.